What is turnover? How does it work? And what should you know about it? When a developer builds a community, often from inception they envision an HOA eventually managing it. So, early in the process, they'll record CC&Rs that establish the rules and regulations for the community. However, until the neighborhoods are completed and well populated, it isn't practical to turn management over to the homeowners. So, in the CC&Rs, there will be provisions for when control should be taken out of the hands of the developer and placed into the hands of the homeowners. If the CC&Rs don't contain those provisions, then by law the default time for turnover is when 75% of all units have been sold, or 7 years after the developer stops selling units, or when the developer voluntarily turns over control by notifying the homeowners and recording a written instrument, whichever occurs first. Before turnover occurs, the authority to manage the community and usually ownership of the common areas both lie with the developer. After turnover, that same authority and ownership is given to the community as exercised through the board. Often a community will have an advisory committee before turnover, but the committee does not have the authority a board would have. When it's time for turnover, the process consists largely of meeting and electing the board. Unless your governing documents say otherwise, the law requires nonprofits to meet annually and provide fair and reasonable notice of the meeting to all members who are eligible to vote. Usually, the turnover meeting will be the first annual meeting for an association. Your bylaws should specify how many board members are to serve on the board, what is required for a quorum, and the percentage of vote required for election. Finally, a couple of tips. Technically, if the annual meeting has been held, the governing documents and applicable laws have been followed, and a board has been elected, turnover is complete. However, there are some additional steps that are advisable as best practices. First, consider recording a written instrument that makes it clear that turnover has occurred. For instance, a certificate of turnover signed by the declarant and recorded with the county recorder will document not only that turnover has occurred, but when exactly it occurred. In the future, this could prove very beneficial if legal questions or disputes should arise. Second, assuming the parties intend for the association to own the common areas after turnover, record a deed whereby the developer deeds the common area to the association. You might be surprised to learn that this is not a common practice. The nuances and necessity might vary depending on whether your community is a condominium association. Regardless, if there is ever a question about who owns the common areas, a legal dispute, or a sale of any portion of the common areas after turnover, a recorded deed evidencing that the association owns the land will be critical. Good luck in this exciting stage for your community, and thanks for watching a video from Welker Benjamin PLLC, a community association law firm.